Good afternoon, everyone. My name is David Tingstad. I'm the managing partner and chair of the business and real estate group at Beresford Booth. I have a challenging topic today. Many of you may not have heard of the Corporate Transparency Act as it's relatively new, but it's something that as business lawyers and business owners, we are all faced with at this point in time because our friends in Congress have passed a new law, a Corporate Transparency Act, that requires all business owners, with certain exceptions, to report the identity of its beneficial owners. So today, what we're going to talk about is what exactly that means and how you go about complying with that act. So as the slide identifies, you will have to report your beneficial owners, and I put that in quotes because it's a slippery concept in terms of who the beneficial owners of your business are, to FinCEN. And you may be asking, well, who in the world is FinCEN? So FinCEN is the Financial Crimes Enforcement Network arm of the Department of Treasury. So you're going to be reporting to the federal government. So this is not a state mandate. This is a federal mandate across all states. And beginning January 1 of 2024, if you form a new business, that business will have 30 days to report its beneficial owners, 30 days from the date of formation. And all existing companies, which are in the multiple millions of us, will have to report its beneficial owners sometime during 2024. So we'll talk today about who has to report, what kind of timing is a part of that, who's affected, if there are any exemptions, and exactly what, to the extent that we know, what those filing requirements are. So let's start with who must report. Existing entities must file your beneficial owner report during 2024. So you'll have basically 12 months to do it. The problem is that if you wait, you might imagine there are over 32 million entities that are, we estimate that's going to be faced with this requirement. So if you wait until December 26th of 2024, it's not likely that you will be able to meet all of the requirements because there are many. So we are recommending that early in 2024, any of your existing entities get working on your beneficial owner report. And remember, not only this isn't just a one and done reporting obligation, you report your beneficial owners and any changes to that beneficial owner's identification, which I'll get to in a minute. And so in addition, entities that are newly formed after January 1, 2024 have 30 days after the date of formation to file their beneficial owner report. So that's who must report. And so our challenge is that FinCEN has to establish a database and a filing procedure before the filing process can begin. And FinCEN has told us that database is not going to open up until January 1, 2024. So we can't prepare everything. We have some ideas because we know what the regulations look like, but we can't tell you exactly what that form is going to look like. So we're trying not to be, filing stuff on January 1. And we're going to let kind of the bugs work out of the system on the one hand, but not for very far, not very long after that. All right. So what that is, then I guess I'd like to discuss who is a reporting company. It's extraordinarily broad. So all corporations, and I'll talk about the exemptions here in a minute, but corporations, limited liability companies, or any other entity that is created by the filing of a document with a Secretary of State, or under the law of an Indian tribe, if you have a document, articles of incorporation, a certificate of formation, so that an entity that is created by that filing. An example of an entity that is not created by a filing is a general partnership. A general partnership is a much less formal thing that is not created by a filing. Similarly, any foreign entity, so if you were formed in, for example, the British Virgin Islands, or in Germany or Hong Kong, and you're registered to do business in the state of Washington, Delaware, Texas, then that foreign entity must also report its business or its beneficial owners. And the challenging thing, as you might imagine, with this kind of reporting, it doesn't matter how long ago your company was formed. So our law firm has been around since 1946. We have formed thousands and thousands and thousands of entities, and they're still in existence. And so we're facing headlong into this challenge of reporting. There are exemptions. And so large companies are exempt. Your question would be, well, what's a large company? If you satisfy all of these tests, other than the bank's requirement that's on this slide, so if you employ more than 20 full-time employees in the United States, your previous tax year shows more than $5 million of gross receipts, and you have an operating presence at a physical office in the U.S. If you satisfy all of those tests, then you are exempt from reporting your beneficial owners. So, by way of example, if you own an apartment complex in New Mexico, and you don't have any employees, you must report your beneficial owners. If you run a law firm in Missoula, Montana, and have 19 employees and $4 million of gross revenue, you must report. And banks are also exempt. They have certain know your customer rules that they have larger reporting obligations anyways. So here's the core filing requirements. And so there has to be personal identifying information for every applicant for new companies. So that applicant may be the lawyer, may be the paralegal who files the certificate, may be the actual client who files, the actual owner or member, president of the company that files its articles of incorporation or certificate of formation. So the applicant must be identified, as well as every reportable beneficial owner. The reporting and filing requirements include the name, address, current passport, or driver's license. Think government issued ID must actually be included. And so I won't get into exactly what a FinCEN identifier is. Not really all that important at this moment, but you can imagine there's a great deal of personal information that is now going to be input and uploaded into the FinCEN database, which is affectionately known as the BOSS, B-O-S-S. It has a name, even though it hasn't been created yet. And any updates have to be filed within 30 days after any change. So, for example, if your company was formed 10 years ago and had 4 members, and you report those members on February 1st, and then of 2024, and in April, one of your members dies, that company must, within 30 days of the date of death, update who the new beneficial owners of that company may be. And this includes things like if the address changes, if a new driver's license or passport is issued, you must update your beneficial owner reporting. This obligation to report is on the company, and your company is required to have a federally issued employer identification number. Think reporting from the Internal Revenue Service at the time you file. And that company must report its trade or doing business names, even if you have not filed a fictitious name or doing business as name with any government agency. For example, in Washington, when you obtain a business license, you need to identify on your master business license application all of the names that the business operates under. So even if you do business under another name and you don't list that on your master business license application, you must report that to FinCEN. So where it gets increasingly challenging is the identification. I've kind of delayed talking about this because it gets even more challenging to identify who or what is a beneficial owner. And what FinCEN is trying to get to is the humans who own and control the business. So for example, if you have a limited liability company that has two members that are both limited liability companies, then you have to keep going up the food chain from that limited liability company to eventually get up to the top to find out who the human members are that flow all the way down that chain. So every individual who directly or indirectly either exercises substantial control, and that's an amorphous concept, exactly what substantial control might be, but any individual who directly or indirectly exercises substantial control over a reporting company or owns at least 25% of the ownership interests of the reporting company. So let's talk about some examples of this. If you are a 25% shareholder in a corporation that is a reporting company, you are a beneficial owner. If you are the president of a corporation, you exercise substantial control over that reporting company, even though you have no ownership interest. You must report yourself, or rather the company must report you as a beneficial owner. This gets increasingly tricky when you start thinking about other types of entities like limited liability companies. You can slice up ownership and control in countless ways with respect to a limited liability company. So a member might own 20% of the company, but also be the manager of the company. So if they're the manager, they exercise substantial control, and even though they own less than 25% of the ownership interests, they are still a beneficial owner. Similarly, what if you were you own 25% of the profit of a profits interest in a reporting company? Well, under the FinCEN regulations, you too would be a beneficial owner, even though you don't have the right to vote or exercise any control over the limited liability company. So it's extraordinarily broad. It goes so far as even to think about if someone holds a pledge of more than 25% of the stock of a corporation, or has power of attorney over someone who owns 100% of the company. That attorney, in fact, doesn't actually own the stock of the corporation, but nevertheless, indirectly exercises substantial control over the corporation. That person would be a beneficial owner. So it's extraordinarily broad. This idea of substantial control, there's some more specifics as far as this goes. If you're a senior officer of a reporting company, exactly where is that? President, vice president? I don't know if vice president. What about secretary? What about treasurer? What about CFO, CTO, CIO? All kinds of different initials we could throw at this. I can't tell you today exactly where that line is about who's a senior officer. Further, if you have the authority over the appointment or removal of a senior officer or a majority of the board of directors, wow, it's extraordinarily broad. If you direct, determine, or have, and I'm reading right out of the regulations here with this slide, or have substantial influence over matters affecting the reporting company. So you have to figure out what's important, and we'll talk about the penalties here in a minute. So it's very challenging. And then they have a catch-all included in the final regulations. Any other form of substantial control over the reporting companies, because apparently the factors identified here aren't broad enough. Wow, there's a lot going on here with this substantial control requirement. Direct or indirect control. So if you're on the board of directors, what if you're one of 9 or one of 3? Goodness, yes, you are a beneficial owner. If you own or control a majority of the voting shares, you can imagine there are a host of arrangements that you might end up with direct or indirect control over a reporting company. And of course, there remains this really fun catch-all where you or otherwise exert direct or indirect control. Then, if the idea of substantial control wasn't broad or unclear enough, so too is the idea of an ownership interest. Term that drives me crazy because I don't know what it means. Does that mean you're a member, a profits interest owner? You hold a pledge, you've got stock? And the answer is yes. Pretty much anything we as business lawyers can think of, and we're pretty creative with this stuff. So yes, it's stock. Yes, it's profits and capital interest in an LLC, and put and call options. Goodness gracious. And you have that is, even though you don't own the stock, when you just have your option to acquire it, that is nevertheless the kind of ownership interest that requires the reporting of yourself as a beneficial owner. And who is responsible to make the reporting to FinCEN? Every senior officer. And so you can imagine president, vice president, manager of an LLC, all have the obligation to cause the company to report the beneficial owners. That means that the president has to go to anyone who the president believes has a beneficial ownership interest in the entity and get their driver's license and submit it to FinCEN. Get passports and submit it to FinCEN, along with a bunch of personal identification information of all beneficial owners. So it's not an exemption to say, well, I don't have that information. The company must go get it for all of its beneficial owners. You must go get it. And the penalties. Civil fine up to $10,000 per violation, and criminal penalties of 2 years in prison. So you must report, and you must file, and you must maintain accurate information about the beneficial owners of your entity, unless you meet one of the exemptions. And if you are initially exempt and then lose your exemption, you must report. So as I record this webinar, today is July 6th, 2023. We believe, even though the final regulations have been passed, there will be a great deal additional information that's coming out, and we will be updating our clients on their obligations. But companies should really, especially ones that are forming now, should be thoughtful about their compliance obligations, because it would be very beneficial if by contract, all of the shareholders, all of the members of the LLC had the obligation to provide their personal information necessary to comply with the Corporate Transparency Act moving forward. Certainly is something that anyone who's considering buying a controlling interest or forming a new entity should be thoughtful about to make sure that they can meet their compliance obligations. So we at Beresford Booth look forward to educating our clients and working with folks to make sure that they can meet their obligations, because it certainly is going to be challenging moving forward. That's the Corporate Transparency Act in a nutshell. More information to come. My name is David Tingstad. I head up the business and real estate group here at Beresford Booth. We'd be thrilled to work with you. You can see our phone number there. Look us up on the web, beresfordlaw.com. And we look forward to working with you. Good luck with your compliance with the Corporate Transparency Act.